So today we're going to be learning about the appointment and removal of a company secretary. Now, of course, the Companies and Allied Matters Act requires that all companies have a person who's appointed as the company secretary. And for private companies, the requirement is that the person should have the requisite knowledge and experience to perform the functions of a secretary, while for public companies, there are certain qualifications required to be a company secretary. So for public companies, before a person can be appointed as secretary, and that person must be a qualified legal practitioner in Nigeria, or must be a member of the Institute of Chartered Secretaries of Nigeria, or a member of the Institute of Chartered Accountants of Nigeria, or must be someone who, for at least 3 years in the 5 years preceding their appointment, has been secretary of a public company in Nigeria, or must be a firm of lawyers or accountants or chartered secretaries in Nigeria. So those are the qualifications required to be appointed as secretary in a public company in Nigeria. Now, in terms of how company secretaries are appointed, um, the board of directors has the power to make the appointment. So usually you have the board of directors appoint a person to be the secretary of a company. And of course, you know that the board can appoint one from amongst themselves to be secretary. So in a company, you can have a person who is a director on the board and also a secretary of the company. So that's how company secretaries are appointed, simply by the board of directors. Now, how are they removed from office? In private companies, the board again could simply pass a resolution um, to remove the secretary. But for public companies, there's a little more of an elaborate procedure that's provided on that camera. Now, with public companies, first, the board of directors has to give the secretary notice stating the intention to remove him as secretary and the grounds on which is intended to be removed as secretary. Now, if the secretary does not make a defense or resign within the period of 7 working days after he's been given such notice, then the board may proceed to remove the person and report at the next general meeting. Now, if the grounds for removal is fraud or serious misconduct, and the secretary makes a defense which the board considers to be inadequate, the board may proceed to remove the person and again report to the members of the company at the next general meeting. But if the ground for removal is not fraud or serious misconduct, and the secretary makes a defense which the board considers to be insufficient, then the board can only suspend such a person, but will not be able to remove the person without the approval of members at a general meeting. So that's the procedure for removal in a public company. I just reiterate that again. So the first thing is that the board would give notice to the secretary, stating the intention to remove him as secretary, stating the grounds on which they intend to remove him, and also giving the person not less than 7 working days within which to make a defense or to resign. If the secretary fails to make a defense or resign within the 7 working day period, then the board can proceed to remove the person and report to the members at a general meeting. If the secretary makes a defense within the 7 working day period, and the defense is insufficient in the board's estimation, then the board may proceed to remove the person. If the grounds for removal are fraud or serious misconduct, the board proceeds to remove the person and reports back to members at the next general meeting. But if the grounds for removal are not fraud or serious misconduct, and the defense made by the secretary is considered insufficient by the board, then the board can only suspend such a person, but would not be able to remove the person without the approval of members at the next general meeting.